Welcome to another episode of Electable. I'm Deb Chubb, and our podcast is sponsored by Indiana Women's Action Movement. Today, we are going to have a very great and lively conversation with Sheila Suess Kennedy, who does a terrific daily blog that is very widely read in Indiana. And I'm going to let and you. I know that you are a retired law professor, and you've been around for a long time, and you've been doing a lot of work. And you worked at the ACLU or ICLU for years as well. So you are really, very well versed in all of this discussion around our topic today, which is the preliminary injunction that is enjoining enforcement of Senate Enrolled Act 1, which is the near total abortion ban that the supermajority Republicans passed in 10 days' time in a special session here in Indiana, and has since subsequently been enjoined by a terrific judge in Owen County, a Republican woman whose name I forgot, and I bet you know, I hope.
No, I don't.
Okay. Darn it.
But I call her that very good judge.
Yes, I will. I will call her that very good judge. I was very impressed with that order, and I do want to, actually, mention a few of the things that were in her order. So because this is complicated, and so I want to help people understand what's happening, because of course we get questions now. It's like, well, wait a minute, I thought the injunction was denied. Now it's allowed, and what does the injunction mean? So I want to try to explain the article too. But Sheila, first, give us a little background about you and tell us, why you're so interested. Why is this so important to you?
Well, first of all, I'm a female, and it is important to me because we have had fits and starts, obviously, but women have finally been seen as equal human beings. We have joined the economy. We have become politically active, and all of the advances that women have made really have been. The only reason we have been able to make those advances is because we have had the control of our own reproduction. The pill was probably the most important thing for women's liberation, if you will. And I say that, I have 5 kids, I'm not, and I have a husband. And I have 3 boys. I'm not a feminist who hates men or a woman who says we shouldn't have children. But the ability to control your own reproduction, the ability to choose whether and when to reproduce, is absolutely essential to a woman's autonomy. Our ability to go into the workplace. When I first began practicing law, it was so funny. I had a discussion with the partner for whom I was working at this big law firm, and I was the first woman, which led to a lot of very funny stories. If we ever go out drinking together, I will share. But the partner for whom I was working primarily was just astonished. She said, ever since women have been able to, control their own reproduction, the secretaries don't leave when they get pregnant. And, it was dawning on him that this ability to control ourselves was an ability to enter the world on a relatively equal basis, and in his case, the world of work. And I think there is ample evidence of the importance of that. So when you look at laws like the one that Indiana passed, you can look at it as an attack on women's health care, which it certainly is. But what it really is an attack on women's equality. It is anti-woman. It is not pro-child. It is certainly not pro-fetus, because the minute that little kid emerges from the womb. Here in Indiana, they could care less. Don't feed it, don't educate it. I mean, so it is the height of hypocrisy. Okay, you asked why I care. That's why.
That's a good, yeah, that's a good reason. And so, I want to say, our state constitution says that all people are created equal and they are all endowed with inalienable rights, which include life, liberty, and the pursuit of happiness. And there was some discussion in her injunction order talking about how Indiana's constitution is more protective of those rights than the US Constitution. And I've heard that here and there over the years that it is in some senses, but I think that's important for people to understand that our Constitution should be used separately from the federal Constitution. And it has been interpreted separately.
Yeah. When I taught, it was amazing to me how many of my students didn't even know that there were state level constitutions. Former Chief Justice Randy Shepard used to insist that the state constitution, he did an article once, a fresh air, I think something to that effect, for Indiana's state constitution. He used to claim that in many ways it was more protective of our liberties than was the federal constitution. But I think there is one of my hot button issues, as you probably know, is civic literacy and the lack thereof. But I think it is important for people to understand that, yeah, we have a federal constitution, and some of us think that has not been appropriately interpreted lately. But we also have a state level constitution and a history of some very good decisions under that.
Right. So I like to say it because it, kind of gives me a little hope, So, and I want to mention
these days.
Yeah, I know it is rare these days. And so I have a few things that I pulled out of this wonderful woman judge's opinion, ruling in favor of the injunction, which stays the SEA one, and I thought it was really great. And so I guess I feel like it's unfortunate that people keep talking about the right to privacy because it's not there, and you don't need to say it. You can just say liberty, which is actually in the Constitution. And so she did a good job, I thought, of making that point, even though she also talked about privacy. But she did a good job of just defining, what does the Indiana state constitution mean when they say life, liberty, and the pursuit of happiness. And so she does. She says, although a liberty is an enormous concept, the court should nonetheless attempt to understand its constitutional significance by considering its plain meaning. Liberty is defined by Black's Law Dictionary as freedom from arbitrary or undue restraint, actually by government, right, privilege, or immunity enjoyed by prescription or by grant, the absence of legal duty imposed on a person. And then the Merriam-Webster Dictionary also provides multiple definitions, including, in pertinent part, the quality or state of being free, the power to do as one pleases, freedom from physical restraint, freedom from arbitrary or despotic control, the positive enjoyment of various social, political, or economic rights and privileges, and the power of choice. And she cites another case, Lawrence, case, and says bodily autonomy has been recognized in Indiana case law as a basic component of liberty. And so I really like that that she's really focusing on the actual words in the actual state constitution. So I think that's really important. And I'm a little distressed when people keep saying, oh, liberty equals a right to privacy. Yeah, I don't get this.
One of the other things my students never seemed to get was, at least when they came in, I hope they got it when they got out, is that the right to privacy, I think, is an unfortunate term, because constitutionally, what that means is the right to personal autonomy. If people think privacy, oh, nobody's going to peek into my bedroom window or go through my personal effects. That is not what the constitutional right to privacy is. The right to privacy in the national constitution is, until they dealt it a death blow in Dobbs, founded on the notion of, again, liberty, and it's substantive due process, which simply means, hey, there are some things that government doesn't get to decide. There are some things that the individual gets to decide in the exercise of his or her autonomy. We get to decide what our life goals are, what is important to us, how many kids we have, who we marry. All of those things are protected against government intervention. And that's what the national or federal right to privacy is all about. It's not about what most people, I just think it's an unfortunate term.
Me too. Me too. I have always thought that, and it makes me mad that Roe is always, mixed up with that. This doesn't make sense.
Well, some people are better at propaganda than others.
Right. So I think, and I want to, here's another excellent point that she makes. And it is about the fact that this is the argument that was made in Dobbs, that this right, and they're calling it right to privacy, I'm going to call it right to liberty. Anyway, that right to liberty did not exist when the Constitution was enacted. And so, Alito at the U.S. Supreme Court and Dobbs said, if you didn't have it then it doesn't exist, and you don't get to have it now.
So we can't vote either. Oh, well, I guess we did do a constitutional amendment for that.
Yeah. So, and that was really, of course, a crazy idea. And the very awesome Republican woman judge, whose name we're going to get eventually, writes, the court acknowledges that abortion was not lawful at the time of the Indiana, when Indiana Constitution was ratified. However, this does not foreclose the language of Article 1 from being interpreted at this point as protecting bodily autonomy, including qualified right by women not to carry pregnancies to term. The significant then existing deficits of those who wrote our Constitution, particularly as they pertain to the liberty of women and people of color, are readily apparent. As Justice Bohm points out in the Brizzi dissent, quote, in 1851, we had slavery in many states, and Article 2, Section of the 1851 Constitution denied the right to vote on the basis of race. Married women had no property rights until they were conferred by statute in 1923. Both of these subjects were debated at length in the 1851 constitutional discussion, but were not included. But by today's lights, are wholly incompatible with our fundamental principles of ordered liberty. So, and she says, our analysis here cannot disregard this reality, particularly when considering questions of bodily autonomy. So another terrific quote by this terrific, and so I don't know, how do you speak to that, Sheila? How do you speak to the evolving nature of our constitutional rights?
Well, it goes back to what I consider to be a very dishonest view of what originalism is. I consider myself actually an originalist, but very different variety than, say, Justice Alito, who also was the author, if you will recall, of the Hobby Lobby decision. I mean, he's a real trip. Sorry.
Yeah, a lot of problems with that guy.
Yeah. The founders of this country, at least in the Bill of Rights, set out a list of the values that they wanted to protect against government encroachment. I used to ask my students, okay, so, what do you think James Madison thought about porn on the internet? And typically you smile, and that's the correct answer. Although I did have a student who said, who's James Madison? Which when I went home, I drank a lot. But the point here is we apply the Bill of Rights and the value, and we try to protect the values that each of those provisions was attempting to protect in a world that the founders could never have anticipated. There's a really good Supreme Court case of maybe 10, 15 years ago where the court had to decide whether the ability, using good technology, of the police to stand across the street from your house and look in your basement to see if you were growing pot, whether that was a search. Well, at the time the Constitution was drafted, a search required entry on the property and a trespass, if you will. But the court said, of course, that's a search. You are invading someone's the sanctity of their basement. But
Yeah,
you know,
using a technique that was not there.
absolutely. The world has changed. Does the First Amendment's free speech provisions protect not just the written word, but radio, television, motion pictures? Well, of course it does. And none of those things were in place when the Bill of Rights was drafted. So that is just if you will excuse, it's a bullshit argument.
Yes, it is. It is completely. I mean, it's so lame. It is just so lame. So yes, this originalism is really, irritating. And I hear a lot of, Republican state legislators, spout off, I'm a constitutionalist.
Oh yeah,
like,
right.
Okay, you're going to have to explain yourself a little more because I don't think you think it means what you think it means. So that's always very shocking to me. And of course, they use that argument to say, well, the Second Amendment says anybody can have a gun, and all of that. I mean, which of course, again,
yeah, we didn't have AR-15s at the time the Constitution was drafted.
Right. It's just really and the fact that they're okay regulating certain constitutional rights. Whatever. I mean, speech is not. Well, I'm not going to go there because we'll get there later. I'm not going to talk about regulated constitutional rights because they are regulated. Okay, so let's see. And it actually this is my next little topic. So this awesome Republican woman judge also says the judicially enforceable liberty rights that are reasonably likely to exist under Article 1 are not unqualified. SB 1, however, materially burdens Hoosier women and girls' rights to bodily autonomy by making that autonomy largely contingent upon first experiencing extreme sexual violence or significant loss of health or death. I did hear another woman, and of course I forget her name, I'm sorry too, who's I think a current law professor who commented on that. And her comment was great. It was like, so what the judge is saying here is that is it still a constitutional right if you have to first, become sexually, assaulted, or get close to death or permanent bodily impairment, do your constitutional rights only kick in after you get to that point? And is that still a constitutional right if you have to wait that long?
Well, first of all, that's stupid. I mean, but see, it gets back to the point I made earlier. This is not an effort to protect babies. This is an effort to disadvantage women, to put us back in the kitchen or in the bedroom, whatever. And so all of these little quibbles about, oh well, you have to be raped first, or you and you really don't get to decide for yourself whether and when to reproduce and all of that. It's all part of, in my view, a reaction to the fact that suddenly some of these, especially elderly white guys, got up one morning, looked around and said, well, looky there are gay guys who are holding hands on the street, and there are uppity women. There are even women reporting on sports on my TV, and there are Black people who think that they are entitled to vote. And I know that's a very unkind characterization, but I don't think it's wrong. I mean, I think there are people who are very uncomfortable in a world where their anticipated white male privilege no longer is getting them where they want to go.
Yeah, it's unfortunate. It feels like a lot of the gentlemen that you're describing, feel like there's a finite pie of rights.
Exactly.
And that if someone else gets some, that means they have to get
less.
Right, that they get less. And I just think that's just such a, kind of a short-sighted and of course not very, intelligent, um, perspective. And it's true. It's sad. It's sad that, that people feel that way because there really are plenty of rights for everybody.
Yeah.
Uh,
This is not an area where zero sum works. Yeah.
Right. And so I just encourage people to consider the fact that, they don't have to give up rights, because someone else has rights as well.
Yeah.
So, okay. So, now let's see. And then she gives her great conclusion, which is great. And I'll just throw it out there. Because of these considerations and the history of Indiana's Constitution being interpreted to provide greater protection to individual citizens than its federal counterpart, there is reasonable likelihood that this significant restriction of personal autonomy offends the liberty guarantees of the Indiana Constitution, and the plaintiffs will prevail on the merits as to their claim that SB 1 violates Article 1 of the Indiana Constitution. So just kind of set up that framework. So to get an injunction, there are these what is a 3-part test, 2-part test, in law school. But anyway, you have to show irreparable harm, that plaintiffs will suffer irreparable harm if the injunction is not granted. And you have to show that you can prove, or show by preponderance that you have a reasonable likelihood of succeeding on the merits. And then, you do these other little weighing things like weighing of the harms, to each side. And in this case, she decided that the harms were much more significant to the plaintiffs if the injunction were not granted than to the defendants if the injunction were granted. And she does a nice job in there too, saying, hey, we have lived 50 years under,
you can take law. A few more weeks. Yeah.
Right. So I don't see the big harm, in waiting. And then you have to do the little public interest will be disserved without the injunction, another consideration, which she, again, does a great job of, saying this is, it would, result in a very large disservice to the public. But I do want to talk for a minute about the notion of the public interest in, okay, so it's Todd Rokita saying it's life, it's about saving babies. And so, and there is, in there's a little seed of, some legitimate interest, that the court considers the public interest in, safety, public safety, which is generally, I think, the balancing criteria that's used in a lot of cases about, civil rights. So it's your personal liberties on one end and public safety on the other end, right? So when we think of like the free speech case, it's not protected speech to yell in a crowded theater, yell fire in a crowded theater, right? Because you're
unless there's a fire.
Unless it's right. You're right. To not lie about it, right? Because you're weighing public safety against your right to say whatever the heck you want to say.
But here's where that breaks down, or at least here's my take on the public safety issue. And this again has a lot to do with the fact that we know more about medicine than we ever did, than the founders did when they were using leeches or whatever. What the world's worst legislature, which is my appellation for ours, refused to take into account was the medical testimony. If I present at an emergency room and a doctor determines that the pregnancy is basically threatening my long-term well-being or life, he or she should be able to make that decision free of a bunch of legislative enactments that have been passed with absolutely no understanding of the medical side of abortion care. I mean, this is not, if it was a situation where every pregnant woman was carrying a baby that was going to be born healthy and she would be healthy and there were no side effects, I've been looking now there. This may seem a little off the side, but it really isn't. There are women who desperately want children who are going through IVF, in vitro fertilization. One of them wrote to a legislator, I don't remember whether it was in Indiana or another state with one of these draconian acts, but she said the process requires that they throw away the embryos that are, or the potential embryos actually, that are not implanted. Is that, she said, surely you're not going to consider that abortion. Oh, yes, we are. So there goes in vitro fertilization. There, I mean, the 10-year-old who was raped. I mean, there are so many, this is complicated.
It's
And our
very
legislature is clearly unable to deal with complex issues. And we know a lot more about everything from fertilization to birth to pregnancies that are not going, I mean, a baby's going to be born without a brain. I mean, things of that sort. Why is the legislature crawling up the uterus of women who need medical care? I mean, this, anyway, it's just, it boggles the mind. It really does.
So
And it's all political. It's all political.
right. Another example is the fact that I'm not even sure now what language ended up in there as to when they consider, this point, what is the 0 point? Is it fertilization or is it implantation? So, and it's important because if it's fertilization, well, that means that the whatever morning after pill, Plan B, well, that's illegal because that expels a fertilized egg, or it keeps it from implanting on the uterus wall. So, or is it when it implants in the uterine wall? So, and then in that case, of course, they still haven't decided, well, where does chemical abortion or medication abortions fit into this whole scheme? So if in either of those cases, the abortion pill, I can never remember that, mifestrone and another something, those are taken after the fertilized egg is implanted in the uterine wall. And so that clearly should be outlawed.
They will tell you that is clearly considered abortion and outlawed in Indiana. There's no doubt about that.
So that means, though, that they have unfinished business because they have to stop people from being able to get it by mail because it is approved by the FDA and you can get those pills by mail.
Well, that brings up what is really, a friend of mine who was head of Planned Parenthood a while back, Betty Cochran, you may have known her.
Oh, yeah.
She used to say, they're not going to outlaw abortion. They can outlaw legal and safe abortion, but women will. When I was a teenager, there were girls in my high school who died from self-administered abortions. We talk about back alley, but some of them used hangers, as you know. I mean, because abortion was illegal and they weren't about to carry that fetus to term, so they ended up either becoming infertile for the rest of their lives or dead. And that's what they're not going to get rid of abortion. They're going to get rid of safe, effective, medically appropriate abortion.
Right.
And their zeal to put us back out, back in the kitchen.
Right. And so the other kind of way that I would like to look at it and, and get your response to is, this notion that Rokita says, oh, babies will die. And so that means that we, cannot enjoin this law, and that is the irreparable harm. And so I always like to talk about what that really means. That they're saying that now, women or whoever, if you can get pregnant, you have some extraordinary duty to volunteer to save this other life. So if, we don't require by law anybody to give up their time of day, frankly, to save another human life. We don't require people to give blood donations, even though clearly that's an opportunity to save another life. We don't require people to learn CPR and administer it if somebody falls down, is having a heart attack, even though clearly that is an opportunity to save a life of someone else. We don't require it. We don't require people to donate organs, even though clearly that would be an opportunity to save the life of someone else. So explain to me why that is different than this extraordinary duty that Rokita believes exists among pregnant people.
Well, first of all, the only thing Todd Rokita believes in is Todd Rokita. But he is one of the most despicable people on the anyway. But the point is, what you have just described simply points out that this is, to use the same term, bullshit. They're not worried about babies. They are worried about women's equality, because we don't require, if you told me I had to spend 9 months hooked up to somebody who had a liver problem and they were using my liver, there would be no court in the land that would require me to do that. And, we can argue philosophically about when human life begins. But getting to there's another case coming up that I have really high hopes for. I'm Jewish. In the Jewish tradition, the fetus has equal moral status with the mother when the head emerges from the womb, not before. There are times in Jewish law where a woman is not only permitted, but may be required to abort under certain circumstances. So why is my religious tradition obliterated by a law that is attempting to assert the primacy of one element of Christianity? It's not even, the ACLU has brought a lawsuit under RFRA, which I think is just beautiful, arguing on behalf of plaintiffs who are Jewish, who are Muslim, who are Episcopalian, and a couple of other religions that I don't remember right now, that don't share this belief that a human is formed the minute an egg and a sperm get together. So why should I have to be governed by someone else's religious belief? We've all been reading lately about the uprisings in Iran under their morality police. This young woman, 22 years old, who was wearing her headscarf, her hijab, but it was too loose, and she died in the custody of the morality police. Well, we're probably not going to get that far, but there are clearly some people in America who consider it entirely appropriate. And what I find really interesting is most of them are those small government conservatives, but they find it entirely appropriate to impose their religious beliefs on everyone who lives in a country which ostensibly has separation of church and state. So, the amounts of hypocrisy that are demonstrated by these laws is just unbelievable.
It is just shocking. And and so that's great. I'm glad you brought up this other case. This one is still pending. I don't know if they'll be combined and be argued together, or
I don't know.
Yeah. And I don't know that they'll also be seeking an injunction again, since they already have one under this new case. But as you said, it's filed under RFRA. It's a religious rights case. So RFRA, of course, Religious Freedom Restoration Act, passed under Mike Pence's governorship. Of course, I don't know anybody in Indiana doesn't know about it, because it was a huge deal. And it really was saying that you could use your religion to discriminate against people who you don't think are behaving the way you want them to behave in your religion. If you can say my religion doesn't agree with how this person is behaving, then you don't have to give them services. And then, of course, I mean, we have to acknowledge the recent Supreme Court ruling in Indiana about the teacher that allowed the Archdiocese Catholic Church to fire a man who is married to a man simply because he is married to a man, which is perfectly legal in Indiana. But because that didn't align with their belief, then they could, they didn't have to honor an employment contract that was perfectly legal, or a marriage that was perfectly legal in Indiana. They could fire him anyway.
That case, in my view, is different. If you have a religious organization, we have federally, certainly, we have long felt that a church or a church school has the right to hire and fire not janitors and things of that sort, but anybody with a religious element to their job description based upon their religious beliefs. That's fine. The question is, in Indiana, because we have vouchers, which we could do a whole thing about those.
Yes,
but because 95% of them go to religious schools, if they are using our money, our tax dollars that have been donated, if you will, by people who that church is discriminating against, that's a different matter. So I believe that school does not take vouchers. If it does, then I think there's another wrinkle legally to that argument. But I'm certainly willing to say, okay, if your Baptist Academy hates Jews and gay people, and of course my usual thing is, you don't like gay people, don't have them to dinner. You don't really have to deprive them of their civil rights. But okay, if you have a school and it discriminates, and it's religious, and that discrimination is consistent with their beliefs, fine. But if they're getting tax dollars via vouchers or anything else, that's a horse of a different color.
Right. So getting back to the ACLU case, sorry, I digress. But in that case, do you think it's possible that the court will require the legislature to create an exemption? So if I'm pregnant and I say, well, I believe deep in my soul that this fetus is not a viable, it's not a human life until after it's born, after it's, can live outside the womb, then I'm entitled. I'm entitled to get the abortion.
I think that would be so impractical I do not think that will happen. But as we were joking earlier, I think there are very few Jews, especially in Indiana. But boy, if they created a workout or an exemption, I think there'd be a lot more Jews. The problem with that is very much like the people who didn't want to serve in the army. I've forgotten the terminology now.
Conscientious objector.
Yes. It was one thing if you came from a church like the Quakers that were known to be pacifists, and then the court would say, okay, well, you're excused from killing people. But if you simply had strong moral beliefs that were pacifist, you had to bring a lot of extraneous evidence into the court to show that you had expressed those beliefs for many years, and you weren't just being a corporal clinger, trying to get out of it. So the practical ramifications of carving out an exemption, I think, would just make that very unlikely.
Well, let's go back to RFRA then. So how does RFRA work? How does let's say I don't want to bake a cake for a gay couple's wedding. So I have to just say what? What do I have to show to say that my religious beliefs preclude me from baking the cake?
Well, RFRA, at least in Indiana, has, after the huge blowback, was modified so that if you are in a part of Indiana that basically one of the cities that has an ordinance that prohibits discrimination based on orientation, you can't do that. But if you are out in the boonies, and we have lots of those, where there is no prohibition against discriminating against gays and lesbians, then
Locally,
you can just do it. I mean, I always think of Obama's remark, because he was saying that he and Biden were so close that there are places in Indiana that wouldn't serve them pizza.
I never heard that. That's great.
Oh yeah, no, I mean, it was funny. It was so
great.
nice to have an intelligent president.
I know.
Yes,
Okay.
okay.
All right. And I'm just going to give out a general apology for my being in the dark. It's because I have a bunch of windows and the clouds came over. So
I was wondering about that, but I thought, well,
Sorry.
perhaps I shouldn't say
and,
anything.
sun may come out now, and then my face will look like a light bulb again. Anyway, so just to, the world isn't ending. So just listen. But okay, so that is great to know. That is one of the technical exceptions that I think a lot of people don't understand about RFRA. And so that your local ordinances can protect still.
Yes, but
in
only
those local
after
areas.
there was a revision to, yeah.
Right,
Yeah.
right. So, okay, so let's say you're not in that area, you're in the boonies, and you don't want to bake the cake. Do I have to say anything? Do I have to say I'm Christian? I mean, so if I say no, I'm not baking the cake, the offended gay couple just has no cause of action. They've got no basis for a discrimination suit.
That is my understanding. But, you raise another issue that we used to explore in my classes, which, okay, you come in to my bakery, which would be really stupid because I'm a terrible baker. But you come in and you say, I want this wedding cake. And my religion says, oh, no, I don't. Why can't I just, I'd love to help you, but I'm really busy right now. The thing that really annoys me about these cases is these are opportunities for people to parade their particular religious beliefs and to pick on people who are generally unable to defend themselves. You don't have to say, why, you sinful whatevers. You can just say, I don't have the time right now, or my oven is going to be serviced for the next. You don't have to be an asshole about it. I'm sorry.
Right.
But
no, I get you. Yeah.
I mean, it is when people are in your face like that, it is their intent to create an incident and to sort of piss on you.
Right. And create division.
It's really unfortunate. These are not the kind of people who make me think, boy, I'd like to go to his church.
Right. Okay. So just to kind of wrap up that little piece. So if the ACLU prevails at some level on the RFRA claim, saying, that, this is a violation of RFRA, and that you can't enforce this law because, there are people, who don't believe that human life begins when Christian evangelists, or Todd Rokita says, and they are being, they're being denied their RFRA rights. So it sounds like you're saying, if there is an exception carved out, which, who knows, then we're still not sure what you would have to say to qualify. But probably you'd have to be a member of an organized church who has, historically held that position.
Yeah.
So, yeah, okay. I could become Jewish. I could do that.
We're nice people.
You are nice people. You are very nice people. I know a lot of great Jewish people. So anyway, all right, great.
And some of my best friends are Christian.
Yeah. No need for all the division, right?
No.
So we don't know when that one's going to come up, but this is very exciting. And so just to kind of also give a little bit of basic framework too, There was the law, it was passed, signed by the governor, it was enacted. The ACLU filed the violation of the section 1 of the article 1 of the state constitution as to life, liberty, pursuit of happiness. And it wasn't initially granted. So it's a little confusing for people because it wasn't initially granted, but was only granted after oral arguments. So that's why there was this delay. Like it wasn't granted, then it is. So, and now, of course, it is still just temporary. It is pending, a full trial on these questions of law. Basically, I guess.
Oh, yeah.
Yeah. So that's what we're waiting for now, and I have no idea when that's going to happen. But it is temporary. And so I like to remind people that this is not, a resolution to this problem.
And I believe that Rokita said he was going to appeal the grant of the injunction to the Court of Appeals. And so, who knows?
Yeah, in the Supreme Court. And he ought to just say, I'm just going to appeal to God. I think sometimes he should just say that, because I think that's what he thinks he knows God or something. So
talked to her yesterday. Yeah.
Yeah. So so it may not even get to that, trial on the merits before the injunction is thrown out and we're back to the ban. So this is very temporary, and it's very confusing. And so I really appreciate your help, trying to make sure that we can make this understandable. Because as you know, this is a critical moment for this issue in Indiana, and for people to take what I like to call the obvious solution, which is to vote for and elect pro-choice candidates to the state legislature. That is really all we need to do. But we need people to get out. Like our good friend Destiny Wells likes to say, Indiana is not a red state. It is a purple state with a voter turnout problem.
And that voter turnout problem, if I can sort of bring in another issue, is a result primarily of gerrymandering, because the legislature has managed to draw districts that are perceived to be safe. A lot of people don't bother to vote. And what is interesting to me is when they are drawing those districts, the only data they have to go on is prior turnout. Now, if everybody there's some of those districts are indeed safe. Indianapolis is now blue. I mean, but in many of those districts, if everybody in that district turned out to vote, it wouldn't be safe, because the data that they used to create that district was based on the turnout problem that Destiny Wells talks about. So yes, we have, anybody who's in business, anybody who is in education needs to turn out and vote blue, because, let me just take a little detour here. I have a very brilliant granddaughter who was looking at good schools. When Texas passed their ridiculous anti-choice bill, she marked Rice off of her list. There are bright girls all over this country who are not coming to Indiana to college because of this law. There are businesses that are not going to be able to get people to work there, to bring in, people who don't live here already because of this law. I mean, Lilly came out after this passed and said, this is going to make it very difficult for us to bring in workers. I mean, this law is stupid on so many levels.
Right.
Yeah, but
the permutations
right.
are just endless.
People turn out, this state went for Obama.
Yes,
remember, right. It can happen.
It absolutely can. And I just, want to note too, I'm sure you may have seen it, Salesforce, yes. 2,300 employees in Indiana said the same thing. They said, yeah, we are really not going to consider investing in Indiana under this kind of a restriction of civil liberties. So yeah, it is. I mean, they didn't all come out maybe when they could have, earlier, like they did when RIFRA was out there. But I think they're really like, I mean, it all happened so fast. And I think that people are really starting to now see. I mean, we've been under a whole different set of rules for 50 years. And, that shift is really taking a minute to understand. And the implications are just endless. I mean, the fact
Well,
that women, will not have as great of access to higher education or even high school. Girls will drop out of high school. What's the point if if they have unwanted pregnancies? And that, I mean, I talked to a woman who was older and she's retired nun and she worked in social services and she said, I've been to houses where there are unwanted children, and
yeah.
I don't ever want to see one of those again. That's, just all those permutations that you just
Many
don't think
years
about.
ago, there a couple of economists issued a book called Freakonomics. You
Yeah.
may have heard of it.
Yes.
And one of the things that their studies had found is that 20 years after Roe, crime went down
Right.
because there were so many fewer unwanted children who were then raised in abusive or deprived circumstances. Yeah, this is
Right.
not the sort of environment. We're not creating the sort of environment that allows for human flourishing.
Right. Yeah. So yeah, everyone needs to read Jimmy Carter's book too, about the impact of women's second class citizenship on third world countries and what keeps them third world countries. So, all right. So, okay. So I always like to make this pitch. If you need to check your voter registration, if you need to register, if you need to find out where to vote or when to vote, and to find out who's on your ballot, you can do all of that by going to indianavoters.com. I like to encourage people to just write down your voting plan. Research shows that it's much more likely to happen if the plan is written down. Again, when will you vote? Where will you vote? How will you get there? Do you need an absentee ballot? You can do that at the same place. You can request an absentee ballot at the same place. And who will you vote for? So all of that is at this one website, and you can accomplish all of the answers to those questions by visiting that site and getting out there and voting. I mean, there's ample opportunity, but just make sure you have a plan. It's easy to slip by. So, all right. Well, thank you so much, Sheila.
You're welcome.
Always just a delight to
Thank
to
you.
talk with you. And
Well, let's hope that the subsequent courts are as good as the judge was who issued this particular opinion.
Yeah. And I'm going to just kick myself all day for not remembering that name. I feel awful. But she's awesome. And she's Owen County judge. That helps. All right. Anyway, so yes, let's be hopeful in that way. And there is hope. And I really, I remember being in law school and my constitutional law professors making that point that we should be looking to our state constitution for civil rights, protections. More than the U.S. Constitution. So here it is. It's happening, and we can do it. So, all right. Well, thank you so much, Sheila. It's great to see you. You look wonderful.
Thank you.
And thank you for keeping up with your great blog. I read it all the time. It's always wonderful.
Thank you.
Encourage people to read it. And so, where do people
go?
To
encourage them.
Where do people go to find that blog?
Just www.sheilakennedy.net.
Excellent. Okay. It just comes to me. So I don't even know anymore. So, okay, great. All right. Well, thank you again. And we'll be back when there's another important constitutional case to talk about.